the principle, so sorry, just checking something. Yeah, the principle of effectiveness and the principles of equivalence and the damages directive. Of course, in order for EU law to impose limits on this issue through the damages directive has to be applicable ratione temporis in terms of succession of laws, and this is going to be a major discussion. Manfredi and Cogeco have clarified these limits imposed by EU law, and you can also find a reference to this in recital 36 of the directive. And therein, I've provided you with quotes from two key paragraphs of Cogeco, which discuss precisely this issue. So one aspect that really tends to be overlooked in this entire discussion is the issue of which limitation period applies to it. It has been assumed in almost all doctrine, and certainly at the level of legislative debate, when the EU legislator was producing this directive, it was just assumed that antitrust infringements would be governed by tort law, and namely in what concerns us now, in what concerns the limitation period. But that is just not necessarily the case in many member states. This is a crucial debate because the limitation periods for tort liability and for contractual liability and for something else, which is unjust enrichment, these deadlines are very different and they vary drastically between member states. And so the outcome of saying that the dispute is governed by the limitation period of contractual situations or of tort situations is drastically different. And it will very often mean that the case is deemed time barred under one and not time barred under the other. Let's take the example of Portugal, which I believe is fits into a group of Germanic influenced countries in which you probably will include Germany, Spain, Italy, France as well has similar solutions. In Portugal, we have a contract limitation period of 20 years. Now, that is already a bizarre state of affairs because why is it? Think about the consequences of that. That means that if you have an antitrust dispute, a manufacturer sells a product to a distributor, that distributor sells it to consumers. The consumers will file an antitrust claim invoking that the damages were passed on by the distributor to them. The consumers are less sophisticated, they have less access to information as a whole than the distributor, and yet they have a 3 years limitation period. The distributor, because he has a contractual relation, he might end up having a 20 years limitation period. And for me, that is a strange state of affairs, but it is what we have in Portuguese law if some of the case law of Portuguese courts prevails, as we will discuss in the next slide. But keep in mind, this is only relevant if the antitrust infringement occurs in the context of a contractual relation between whoever infringed competition law and the person who was injured by that infringement. It's also only relevant if you are discussing a situation to which the rules applicable, ratione temporis, are the rules prior to the directive and its transposition. Because after the directive, this discussion disappears because the limitation period has been harmonized and it is throughout the member states. In almost all member states, it is now 5 years. There is the directive allows for longer, but it imposes a minimum of 5 years. In Portugal, we have had the issue of does the contract limitation period apply when the antitrust infringement occurs in the context of a contractual relation. We've had that issue discussed in 12 cases. 8 of them concluded that they should apply the tort limitation period. However, only one of them actually discussed this, so it's not exactly it's not exactly we don't have the idea of settled case law, but it's certainly you don't have a lot of legal reasoning in the others for why they applied the tort limitation period. And then you have 4 cases which applied the limitation period for contract disputes. And there you do find discussions of the issue, and you do find legal reasoning for why you should, and including legal reasoning by the Portuguese Supreme Court. This reasoning is based on settled Portuguese case law, not specific to the limitation period, so applicable in general to determining the scope of tort and contract liability. And this settled case law says that if a dispute can be qualified at the same time as contractual or as tort, then the contractual liability rules will apply. The reason for that is that that case law was developed in a context where the issues being discussed were, for example, fault, proof of fault, and things like that, where contractual rules were more favorable to the claimant. And so it was deemed that if both regimes applied, you should apply the regime that was most protective of the claimant. That doesn't really apply in the case of antitrust, because in the case of antitrust, if you apply contractual rules, it does apply in the regime of antitrust as well, because if you apply the contractual rules for a limitation, you will have a longer limitation period there as well. And then you have a great example of a discussion that was really going into details about this, which was in our Apple case, very parallel to the Apple case in France about jurisdiction clauses. And there, the first instance court from Madeira actually went to the point of saying they were confronted with a claim that only invoked competition law infringement, only. In fact, some of those competition law infringements derived from the letter of the contract. And the competition, the generalist court in Madeira actually said that the claimant was disguising a civil law complaint as a competition law complaint, and said, this is civil law and I'm going to apply contractual liability rules because basically you're invoking violations of good faith and so on. And it went all the way up to the Supreme Court, and the Supreme Court confirmed that contractual rules would be applicable to it, and said that Portuguese courts did not have jurisdiction because of the jurisdictional clause that said that you should go to Ireland. Right? And this was also discussed in France, and it went in a referral to the European Court from the French courts. That being said, this discussion is very often not relevant. In principle, it's never going to be relevant when the damages are passed on along vertical chains, right? And in the trucks cartel, for example, the discussion doesn't usually come along because usually the action is filed by indirect purchasers against the manufacturers of trucks. There is no direct contractual link, and so usually it will not be possible to invoke this discussion in that case. But then you also have the unjust enrichment provision. The unjust enrichment provision also tends to appear in several disputes. We've had a few examples of that in Portugal. This provision is also subject in Portugal to 20 years limitation period. The idea here is relatively simple. Is to say, well, I paid a higher price than I should have. The difference between that price that I paid and the price that I should have paid is unjust enrichment, and the unduly paid sum should be restituted. This is a subsidiary figure, but there is an argument to be made that if the other sources of liability are time barred, then you can invoke this figure subsidiarily. And in fact, it has been applied in at least 2 cases that I'm aware of in Portugal, which are mentioned there. The second one, Nós versus PT, it was a particularly important use of this figure because it saved that action from being time barred, at least in what concerned the surcharge damage. It's a sister action, Oni Telecom versus PT, was deemed time barred under tort, And this action with the same infringement, same fundamental facts, was not deemed time barred because of applying the unjust enrichment limitation period. So there, it really made a difference. Now, should we be looking at this as a matter of national law? Maybe not. Maybe not. Because often in disputes where you are applying Article 101 and 102, you will find that EU private international law is applicable and you're applying the Brussels regulation or the Rome 1 or 2 regulation. And all of these regulations have their own concept of what is a tort dispute and what is a contract dispute. It can't be up to the member states, it can't be up to national law to decide what is a contract dispute or what is a tort dispute for the purposes of applying these rules, applying these EU private international law rules. It gets tricky here though, because then you can say, okay, fine, but they're not free to decide that for the purposes of applying these rules, but they will be free for the purposes of applying other rules, which are still within the realm of national law, such as the limitation period. I'm not entirely persuaded by that because I think that this will create very unreasonable solutions. And there is an argument to be made for the uniformity of interpretation of EU law, because you're also applying a right that derives from EU law, the right to damages. But I can see that this is a very, very undiscussed issue yet, and that much more clarity is required on this. In any case, after the directive, well, 10 years down the road from now, this issue will become obsolete because of the harmonization of the limitation periods in the directive. I would now like to move on to the issue of old national rules on limitation periods. And the reason I want to do this is to point out that very often courts will be able to completely avoid these very, very complicated discussions about the temporal successions of laws and about whether the directive is applicable and about whether the principle of effectiveness is limiting national law and about fundamental rights, etc. These are really, really difficult discussions that will take up a lot of energy of the court. And sometimes they will find that it's possible to avoid them simply by interpreting their old tort law or limitation periods, perhaps even contract limitation periods if they deem those to be applicable. I personally think that it shouldn't be. I think it should always be governed by tort deadlines, but in Portugal and in other cases, in other countries, as I've said, the jurisprudence doesn't support my point of view. Courts deciding these individual cases can simply look at these situations with the old national rules and say, even under the national rules, they're not time barred. And in order to do that, by doing that, they will be basically avoiding the discussions and saying it doesn't really matter if we apply the new rules or the old rules, the case is not time barred. However, in many countries, in order to do that, they're going to have to move away from interpretations that have been done in the past by themselves or by higher courts. That is certainly the case in Portugal, where we've had fairly restrictive interpretations of our limitation period. And so even though that doesn't prevent a more liberal interpretation of the limitation period that is more protective of rights in future cases, it still creates an added challenge for judges who are trying to avoid the discussion by simply saying, even under the old rules, this would be fine. I think that there has been too much attention placed on the duration of the limitation period, because from my experience, the vast majority of cases, the truly decisive discussion is about when the deadline begins to run and not about what is the deadline. Don't forget that you have very different deadlines. You have Spain with 1 year for torts before the damages directive. You have other countries with 10 years. So it really varied a lot. And now the damages directive sets out 5. And then there are also a lot of very significant variations between member states. In Portugal, for example, there has been a lot of discussions about when can you deem the person to be aware of the infringement. And this is, I'm going to get back into this in a little bit, but I just want to point out that as the court itself has said, especially in Pajeco, antitrust is different. It's not, you can't just look at it as any area of tort. It's highly complex area where the facts are very complex and where determining if there is an infringement is very complex. And we need to keep that in mind because general tort rules were developed for situations that are fairly straightforward. If my car is parked by a construction site and bricks fall on my car, I do not have to have legal training in order to understand that I have a right to compensation. And so knowing the facts that bricks fell on my car from that construction site, it is reasonable to say, well, the limitation period starts to run from there. That kind of logic doesn't really apply to antitrust infringements because very often people who are not familiar with the intricacies of antitrust will be tempted to say, well, he already knew that this was happening. Yes, but to meet the requirements of there actually being an infringement of antitrust, it takes a lot more than knowing that somebody did something. You have to know what the market definition is, and that is highly debatable most of the times. You have to know if the infringement covered a lot of the market share or not. You have to know if there was a dominant position if you're invoking a unilateral practice. You have to know if there is actual discrimination and if discrimination is justified. You have to know, if you're talking about margin squeeze, you have to know the costs of the undertaking in question and the costs of efficient operators. And there is such a level of complexity to determining if there actually was an infringement, which is necessarily a previous discussion to knowing whether or not you have a right, that to just say, oh, well, the bricks fell on your car, you should have done something about it. It's just not that simple. And the more we look at the reality of cases, the more we see that even after decisions of competition authorities that say that there was an infringement, even after those decisions, very often companies don't know if they have a right to be compensated. So imagine before. Another issue that has been really complicated in Portugal is the issue of complaints to competition authorities, and this also came up in Norway and was taken to the EFTA court in one example. This is a particularly tricky issue because the typical attitude of a company who suspects of an infringement is to make a complaint to the competition authorities. They want the competition authority to investigate it and to determine if there was an infringement, because it is very, very difficult for private persons to, especially in continental Europe with no tradition of discovery, it is very difficult for private persons to have access to confidential documents in possession of others that they need in order to determine if there was an infringement. Competition authorities can do raids. They can use their powers of authority to require companies to submit documents. And therefore, when a company suspects an infringement, it will complain to the competition authority. And when complaining, it will make it sound as much as possible as though it knows that there is an infringement because it's trying to persuade the competition authority that there is an infringement. So it's going to build up as good a case as it can. But that doesn't mean that it actually knows that it's an infringement. That doesn't mean that it has the evidence that there was an infringement. That doesn't mean that it is in a position to actually know if it has a right to be compensated. And you have to look at that on a case-by-case basis very carefully. The reason this is so important is because in Portugal, and there was the temptation to do this in Norway as well, the idea was, well, if you filed a complaint to the competition authority, you knew about the infringement, the deadline starts to run on the date of your complaint. That is, it's possible that that is the case, but that might also not be the case. You have to look at the facts of each circumstance, of each specific circumstance. And another consequence of doing this is that you punish the companies who do complain, and you reward the ones who are quiet. The ones who are quiet also probably suspected that there was an antitrust infringement, and they just didn't complain, and therefore their limitation period would not have elapsed. And the one that did complain and helped competition authorities become aware of infringements and helped public enforcement, they get punished, because then the courts would say, well, you complained, you knew about it, you should have done something. You also, in this discussion, you also need to take into account the characteristics of the national system in what concerns what do you have to do to interrupt the limitation period. Is it possible, and what do you have to do? Okay, let's move on to the applicability of the damages directive. And so far, nobody has been asking me any questions, but I would invite you to do so. Feel free, please. So the damages directive has a provision at the end about its temporal scope. It's Article 22. And this provision says that member states shall ensure that the national measures adopted pursuant to, well, the transposition measures, in order to comply with substantive provisions of the directive, do not apply retroactively. So substantive provisions of the directive do not apply retroactively. And then it says, and the member states have to ensure that the measures which are not substantive do not apply to actions for damages of which national courts were seized prior to 26 December 2014. So it doesn't actually say that it has to apply to the actions for damages after 26, which were filed after 26 December 2014, and we're going to need to clarify that via interpretation. This article was already discussed in COGECO, and the court said in paragraphs 28 and 29 that number 2 on procedural provisions, a contrario, means that member states can choose if the new procedural provisions are applicable to actions filed between 26 December 2014, so the entry into force of the directive, and before the member state transposition. So they're free to do that. However, we can take, and they also said, of course, they repeated that substantive provisions do not apply retroactively. And we can take a contrario from what the court said, I believe, that this means that member states must apply the new procedural provisions to actions filed after the transposition. I think this is a general principle of law, that the procedural provisions are applied immediately. I also think that this is fundamental for the effectiveness of the directive and complying with its obligations, because if member states were free not to apply the new procedural provisions to new actions after the transposition, or immediately to actions after the transposition, that would make it that would mean that they would not be obliged to make the new procedural provisions of the directive enforceable in their jurisdiction for many years to come. Somebody is asking for the case references to 2 of the Portuguese cases that I mentioned. I have published a study which you can find online at the law school's Economic Law Research Center. So if you just look for Jurisprudência Portuguesa de Private Enforcement, so Portuguese private enforcement case law, you will find this study, and it has all the references of all the private enforcement cases, including that one. Advocate General Cocotte went a little further than the court, and she said that the procedural provisions apply to facts preceding the directive if the actions were filed after the transposition or the transposition of the directive. There is an additional discussion here, which is why is it actions filed? It should be immediate application of procedural provisions within certain limits, of course. But procedural provisions of procedural issues which are only decided after certain rules come into force, they should be applicable immediately. And this still hasn't been discussed in the case law. Crucially, the court avoided actually taking a position on whether time barring rules were substantive or procedural, the time barring rules of the directive. it's understandable that the court was really cautious about this because it still had very fresh in its mind the trauma from Tarico 1 and Tarico 2. Still, it did qualify these limitation period norms as exercise of rights. So it said that they were not constitutive conditions of the substantive right. They were rules concerning the exercise of rights, and that's why they are governed by national law. I would argue that if it's not a substantive constitution, a constitutive condition of the right, so it's a substantive provision. But I admit that this is not necessarily the case, and that this is subject to discussion. And Advocate General Kokot, of course, of German legal training, said that they were substantive, but she didn't actually justify that under EU law. And there is a lot of case law of the EU that seems to suggest that limitation periods are procedural. But this is a debate that really needs to be continued before the court. Differently from the courts, differently from the case law of the court, which is still uncertain about this, many member states are absolutely unequivocal when they say that limitation periods are substantive rules. Of course, this is not a national law issue. If we're discussing the applicability of the damages directive, this is an EU law issue. And don't think that, but wait a minute, we're not just, what we really want to know about is the applicability of the transposition, because there is no direct horizontal effect. So what we really need to discuss is the applicability of each national law, and each national law might have its own rules on the temporal scope of that transposition, and that rule has to be interpreted in light of national law concerning whether limitation periods are substantive or procedural. Well, depends on how the national rule is written. Because if the national rule on succession of laws or on the temporal scope of the transposition is written in a way that allows for multiple interpretations, so if it's ambiguous, you still need to discuss the temporal scope of the damages directive, and therefore you still need to discuss if limitation periods are substantive or procedural under EU law, because you will be subject to the obligation of interpreting your national transposition to the extent possible in accordance with the directive. So if the interpretation of the temporal scope is ambiguous, you need to interpret it in a way that achieves the result which was intended by the directive. That, of course, is old case law going back all the way to Maanen. Even if we consider time barring rules to be substantive, that's not the end of the discussion. Okay, so even if you want to go ahead and say, okay, this is a substantive issue, fine. But what does it mean when you say that there can be no retroactivity? This is far from clear. There are different types of retroactivity. So what does the directive mean when it says that it shouldn't be retroactive? And I would venture a guess that none of the transpositions has clarified what do they mean by prohibition of retroactivity. Oh, actually, this is not true. This is not true. In fact, we'll see that some have clarified it in a way that is actually, in my opinion, infringing the directive. But not for all issues. So just for some specific issues. So we need to still clarify what does it mean when we say that the new limitation rules are not retroactive. The first thing I would say about this is that we can obviously not have zombie actions, right? So you can't have cases, actions, rights that have died being brought back to life by the damages directive. Right? But please keep in mind, I'm only discussing being brought back to life by the damages directive. This does not mean that the rights could not be dead if this was required by the principle of effectiveness even prior to the directive. That is a different discussion. Right now, we're only talking about the applicability of the damages directive and the national transposition. So we can't have zombie actions. If the old limitation rule if the period under the old rule had passed, then the action is dead forever. A.G. Kokot also argued in this sense in Cogeco. But what happens if the new rule comes into force while the old deadline has not yet expired, right? In this case, in my view, the new rules have to be applicable for the future. What does that mean? Does this mean that they can't apply at all because the facts preceded the entry into force of the new rules? Or does it mean that they still have some effect for the future if the action had not, if the right had not yet expired? So, for example, if 1.5 years have elapsed when the transposition comes into force, I'm using the Portuguese example, if 1.5 years had gone by, does this mean that the deadline becomes extended from 3 to 5 years, right? Because the old rule said 3, the new rule says 5, and therefore, instead of having only 1.5 year more to file the case, you now have 3.5 years more to file the case because the new rule entered into force. And member states have disagreed tremendously about how to interpret these rules, and some of them have even written down those disagreements in the transposition of the directive. So it is absolutely fundamental that we get referrals to the ECJ to clarify exactly what is the implication of the entry into force of these new rules. And what exactly does it mean when we say no retroactivity, if indeed you are to qualify them as substantive? It also means that most likely the European Commission is going to have to do infringement proceedings. And the reason I'm saying this is because if you look at the transpositions, they don't add up. Some of them have to be wrong because they're contradictory. So some of them are going to require infringement proceedings unless the Commission just wants to let it slide. So for example, in France, Germany, and Lithuania, they went with the solution that I said earlier. So the new rule applies to the future. If the action is not dead, you extend the period until the end of the new period, and you deduct whatever time had already elapsed. In Poland, similar, but if I'm not mistaken, the new deadline starts counting afresh, right? So it's an even longer extension. In Ireland, the new rules were deemed not to be applicable at all to facts prior to the transposition. So they would say, oh, that's retroactive, we don't even apply them at all. And in the UK, they said that the new rules would be applicable only when the infringement and the damage occurred after the transposition. And if I'm not mistaken, this would be applicable even to continuous infringements, meaning that if the infringement had started before the transposition, you would never be able to apply the new rules because it had already started before the transposition. So widely diverging views about when do you apply these new rules on limitation period. I have some questions here from people. Grigoris asks, what about member states that were late in transposing the directive? How would the procedural provisions apply ratione temporis? So I think that the main issue here that you're raising has to concern the absence of direct horizontal effect. If you were late in transposing the directive, that doesn't really matter when it comes to disputes between claimants who are if the defendant cannot be considered state in the very broad definition that the case law gives it, right? A public company, for example, controlled by the state would be state probably. But you cannot invoke the directive against them. There is no direct horizontal effect, which means that what really matters to know when the new rules came into force is when the transposition was done. So your only legal remedy is if you are prevented from obtaining damages because your state was late to transpose the directive, and as a result, your right was time barred, and it shouldn't have been if the directive had been complied with. Your only legal remedy is to file a claim against your state for its tort liability for an infringement of EU law. And Alexandra asks, why did the EU legislator choose this open interpretation? Alexandra, I think you're going to have to clarify that question for me because I don't, I've moved on and I don't know which interpretation you were referring to. Do you want to clarify? Okay, maybe maybe she'll write something in a little bit. Let's move on to issue 6. No, we have another question. Filippo asks, what are the odds that the Commission will start an infringement proceeding, given that it seems it's like a problem that will solve itself in the long term as old cases die out? I don't know. We never know the odds of the Commission starting infringement proceedings. It's also possible that they could send a letter and the member state would change its law. We don't know, but don't underestimate how long it's going to take for this question to disappear. Because of the nature and duration of practices and length of public enforcement proceedings, we might be talking about these issues for another 10 years to come. And Alexandra clarified in the meantime, she said, the directive says that member states can choose for the limitation period's applicability. Why didn't the EU legislator choose a more straightforward solution? The directive doesn't really say that. That's a matter of interpretation of the directive. But you're right, the EU legislator could have been clearer, but don't forget the EU legislator is the member states and also the European Parliament. But the Council has to agree on what's written there, and the Council has the member states have widely diverging views. So in this, as in so many other things in the directive, it just wasn't possible to come up with a solution that everybody could accept. So for example, the principle that was affirmed in Skanska, the idea that the economic unit is liable for the infringement, so the parent company can be held liable, that was fairly foreseeable, and yet the legislators refused to put that into the directive. And the court did its job, and said, well, that's just clear that that's going to have to be the case. But it wasn't included in the directive because there was no agreement between the member states. I think the same thing can be said here. And Francisco says that in 2018, Murcia court claimed that the directive can't be applied retroactively. So the only option was to follow the path of general tort rules. I'm going to talk about decisions in Spain in a little bit. There has been widely diverging views in Spain from the courts, but there has also been, even from the Supreme Court in Spain, the tendency to interpret old rules in accordance with the directive. In the Netherlands, we've seen this, and that is a great attitude that basically, I'll come later to why that is a great approach and why I think that it's probably accurate. Not because you have to interpret the old rules in accordance with the directive, but because there is an indirect way that leads you to doing that. But you're right that the directive wouldn't be applied retroactively in what concerns the limitation period. Generally, it's just that we don't know what retroactively means exactly. And then you ask if I think Portugal would go the same way. I have no idea how these issues will be decided in Portugal. We don't have precedents yet. Our first cases are pending. They are pending, however, before a specialized competition court. So unlike in Spain, where you're going to have many different people with many different trainings and sensitivities pitching into this discussion, in Portugal we have a much more limited number of judges at a specialized court who are very familiar with competition with the competition law, and they are the ones who are going to be deciding this. So I think that the approach here might be different than what you would find in courts that have fundamentally been trained in civil law. Okay, moving on to issue 6, which is the limits deriving from EU law. And before I call on our guest speaker, I'm just going to give a short introduction here. When we're talking about the limits deriving from EU law, it's all about effectiveness. It's like, to paraphrase the real estate motto, it's effectiveness, effectiveness, effectiveness. But it's been underestimated to the impact that fundamental rights have here. Access to justice, the issue of fundamental rights, will also lead you to the very same result as the principle of effectiveness most of the time. And I think we need to have more of these discussions in parallel, effectiveness and access to justice, because really the problem is the same. There is a good case to be made that the damages directive, the rules on the limitation period in the damages directive, are basically just the view of the EU legislator about what is needed in order to ensure the effectiveness of the right to damages. In fact, there is a constitutional argument in terms of how you define the powers of the European Union to legislate, how far can it go? There is a constitutional argument to be made that if the directive went beyond what was necessary to ensure effectiveness, the European Union would not have had the power to adopt those provisions, meaning that provisions that went beyond what is required to ensure effectiveness would be invalid. That is an interesting discussion for the court to keep in mind when it's applying the principle of effectiveness in antitrust cases, because if the court says, well, this rule, which is in the directive, is not needed for it doesn't apply before, it wasn't required prior to the directive by the principle of effectiveness, because it's not absolutely necessary to ensure effectiveness. Somebody is going to turn around in the following case and say, and claim the invalidity of that rule of the damages directive. I mean, why wouldn't they? There is, therefore, a natural tendency for the case law to harmonize the interpretation of the requirements of effectiveness with the rules that you find in Article 10 of the directive. And you've seen that in Spain, you've seen that in the Netherlands. And they do this except for the precision that it has to be a 5-year deadline, because that is really just going into a very fine detail about the limitation period. Whereas the case law of the court clearly shows that it really has to be, effectiveness requires a case-by-case assessment. So you can't really use effectiveness to say the deadline has to be exactly 5 years. In some cases, 3 years is fine. In some cases, 5 years is not enough. So it really depends on exactly what the circumstances are. And I've put here the rule of the directive because this Article 10, because for those of you who are unfamiliar with it, this is the portrait, in my view, of what the legislator thought, that in antitrust cases, with all their specificities, with all their complexity, this is what is needed to ensure that the right to damages is effective. First, the deadline cannot start to run before the infringement has ceased and before the claimant knows or can reasonably be expected to know the following: that the behavior, and he must know about the behavior, okay, so the facts of the behavior, but not just that, he must know that this set of facts constitutes an infringement of competition law. Then he must know that the infringement caused harm to him or her or it, and he must know the identity of the infringer. All of this is required in the harmonization of the limitation rule. Then you have a 5-year deadline, and even more importantly, you have the requirement that while there is a public enforcement investigation going on, follow-on actions are suspended. The limitation period for follow-on actions is suspended. And the suspension is only lifted not when the decision is adopted or made public, or no, it is lifted 1 year after the decision becomes final, becomes res judicata, right? Now, why is this so? Let me quickly go over some of these reasons. Let's think about some of these things individually. When does the deadline begin to run? Okay, the first question you need to ask is, when can you be deemed to be aware of your right to damages? If you're aware of the behavior, is that enough? And by the way, what does it mean to be aware of the behavior? Sometimes you can suspect the behavior, but that doesn't necessarily mean that you know that there is a behavior, because knowing that there is a behavior would require, for example, that you have access to invoices to other clients, to contracts with other clients. So you can suspect, you can even have insider information or whatever, that contracts with other people do include something, or that invoices, that prices charged have had certain characteristics or whatever. But if you don't actually have those documents, can you really say that you are aware of that behavior? Or being suspicious that there is a behavior is not the same thing as being aware that there's a behavior. must you also know that there was an infringement? And this one is the trickiest one, because really, if you do a mental exercise as a claimant of what you have to prove in court in a standalone action that there was an infringement, if you do this mental exercise, anybody who has tried to prove an infringement of competition law will know that it is never clear cut. You never go to court with a clear cut case. Oh, there was an infringement. There's so much to debate, always. There are so many things that are based ultimately on complex economic discussions. If nothing else, if you're claiming an infringement of Article 101.1, it might be that the requirements of 101.3 are met. Sure, it's not your problem, it's the other guy's problem, but the other guy might be able to prove that they're met, in which case there is no infringement, in which case you have no right to damages. Abuses of dominant position also can be economically justified with positive aspects. When you really get down to it, there is so much uncertainty that unless there is a public enforcement decision, it is, in the vast majority of cases, it's just not reasonable to say that you know that you have a right to damages. You know that there was an infringement, and therefore you know that there was a right to damages. That's just not reasonable. But let me not be, entirely pro-claimant here, because there's also another counter-argument, which is to say, well, if that is so, the limitation period never starts to run, because unless there is a decision, people never really know. And that is an absolutely fair assessment. That is a perfectly fair criticism. I just don't know how to get around that. Basically, what this means is there is the need to balance the protection of legal security for the infringers, that they can't be forever exposed to actions, and on the other hand, the right to damages when people do find out about the infringement. And this brings us basically to the discussion of absolute limitation periods, which we will come to later. Must you be aware of the extent of the damages? There has been hints already in case law that you might need to be, and as you saw, the Article 10 doesn't necessarily require you to know the extent of the damages. So maybe that's not crucial for effectiveness, as long as you know that there were damages, and then you can go to court and obtain evidence and discuss exactly what those damages were. Damages might be ongoing. So that's probably not a decisive aspect. Must you be aware that you had some damage, that you were affected by the infringement? Oh, absolutely, absolutely. And this is more complicated than you might think. I'll give you an example from Portugal. Recently, there was a decision identifying an insurance cartel that affected, according to the decision, the insurance cartel had certain practices. It basically was a rather crude market splitting, client splitting agreement. And the decision says it affected large clients. However, the decision, at least the non-confidential version of the decision, doesn't give us a definition of what large clients were. It doesn't say if they selected individual large clients or how they determined what a large client was. So when a company comes to you as a competition lawyer and asks, are we affected by that decision? You have no idea. All you can say is, well, looking at your turnovers in how much insurance you buy, you seem like a large client, but I have no idea if you were affected by this cartel because I don't know how they define large clients. Maybe they have a list of large clients and you're not on it. I don't know. So even though the non-confidential version has been published, companies still have no way of knowing if they were affected. So please be very careful not to jump to conclusions that even if there has been a public enforcement decision, it might not be clear who was damaged by the infringement. By the way, this is also something to be considered by competition authorities, who should take this into account when they draft the non-confidential versions of their decision. Must you be aware, must you know who the infringer was? Well, Article 10 of the directive says so. Yeah, it's kind of hard to exercise your rights if you don't know who the infringer was. This is interesting because in Portugal, for example, it's not a requirement. But I think clearly, how can you effectively exercise your rights if you don't know who you're exercising them against? You can't even effectively interrupt the limitation period because you have no one to express the intention of exercising the right. And then there is the very complicated discussion of what's the moment. What's the moment if you have a public enforcement case where you become aware of the infringement? Is it when there was a statement of objections? Of course not. Statement of objection says we think there is an infringement. It doesn't say there was an infringement. In the end, they might conclude that there wasn't an infringement. So they might be wrong. They might could change their mind. So clearly, just a preliminary declaration of intention to find an infringement cannot start the clock. Is it when there is a press release about the decision that was adopted? Well, you know, at that moment, you know that some competition authority said there was an infringement. You might not have enough details to understand what the infringement was. You might have. The question is, legally speaking, that press release is not enough for you to actually know. It's not binding on the commission. The press release might be completely wrong. The decision might not say that. And so you can't really trust the press release. You need to see the decision. Is the publication of the non-confidential version of the decision enough? Yeah, probably. If you have the non-confidential version of the decision, if the non-confidential version includes all the information that you need in order to determine that there was an infringement and that you were affected by the infringement, which might not be the case, but if it does, that's probably the moment. However, what if the decision was not final? And this is where things get complicated. There is a reason why the directive said that the deadline does not start to run from the publication. It starts to run when the decision is final. And the reason for that is that what we're asking is, do injured parties know that there was an infringement? You do not know that there was an infringement just because a competition authority says that there was an infringement. We live in countries with rule of law. And a administrative authority might be wrong. It might even be corrupt and be abusing its powers, declaring infringement that never existed. We can't just assume that an infringement exists just because the competition authority says it does, right? And I'm sure the infringers would be the first to agree with me. So the only time when you can really be reasonably expected to be required to know that there was an infringement is when there is a public decision which is now final, right? If it's final, it means that either it was not appealed or it was appealed and the courts have confirmed it. And then you know, as a matter of law, as a matter of fact, that there was an infringement, and it is not reasonable for you to still have doubts, right? So what is the reasonable period? But there is an additional issue, sorry. So this might take years, right? Because if there are appeals, it might take 4 or 5 years. And that's the solution that is proposed by the directive. So I'm not saying anything surprising. But there is another issue, which is the reasonable period after you have access to the decision. And the directive says you have to wait 1 year. Why is that? Because preparing an antitrust case is not easy. Once you have access to the decision, you need to go over it. You need to consult economists. You need to look for more data. You need to purchase data that is private for market reports, etc. You need to do a lot of things. It takes months to prepare a case. It takes months to assess whether indeed you have a right to damages and you're going to court. Sometimes you need to get litigation funding. Sometimes you need to find funding from other sources. It takes a long time. You can't require people to move as soon. You can't start the clock as soon as as you have knowledge, because it's going to take a long time to assess the information that you have access to. Plus, you might still need to ask for access to additional evidence. And the next issue is the deadline suspended during the public enforcement investigation? And is it automatically suspended? That's really what we want to know, because there is a public enforcement investigations. What if parties could do something to interrupt the limitation period? Does it depend on what parties have to do in order to interrupt the limitation period? And this is discussed in Cogeco, so I'm not going to address it because our guest speaker will. But I want to, before moving ahead, address some of the questions that I've received. Alexandru, are you asking to intervene?
Yes, I have 2 questions, if would be possible.
Yeah.
So thank you for the points you raised. I think they're very valuable and they're valid. But you talked about the idea of fundamental rights. So that would be one perspective, but I think the other perspective would be the perspective of the infringers, right? Because the idea of time barring is a way of protecting also the interests of those who infringe the law, and they should have some sort of expectation, legal expectation about the time in which they're exposed to litigation.
Sure.
So how does it work? How do you manage to balance these two rather different interests?
Yeah, yeah. Well, courts have been doing that. Courts have been finding that balance. I would argue, for example, that if you have been implementing a cartel and doing your very best to keep it secret because you know it's illegal, you're not worthy of legal protection. And I'm not alone in this. The directive says this. It says that if it's a continuous infringement, it cannot start until the infringement is over. The clock cannot start to run. In the UK, they have the same solution under their general rules. If you've kept your practice secret, why should we reward you for your success in hiding your illegality? So we have to look at this proportionality in terms that allow for, don't destroy completely the legal piece, and companies cannot be indefinitely waiting to know if they're responsible for something. But at the same time, we have to look at it and say, does this behavior merit protection in this way? Up to when, right? So, I mean, I think that the question you raised is fundamental, but it's going to have to be discussed on a case by case basis. When Petra asks if when does decision become final, when it is subject to court review, when the res judicata effect of the NCA decision, or when the administrative court finally confirms it. So a decision becomes final either if it is not appealed within the legal deadline, or if it is appealed but it is confirmed by a last instance court, or by a court which is not last instance, but then that judgment does not get appealed. So it's whatever the time, whatever that moment is in the specific case. And Alexandra says, but if you need to be aware of the extent of the damages, wouldn't the confidentiality, for instance, of market values interfere? Yeah, it's incredibly difficult to be aware of the extent of the damages, and the extent of the damages will be highly debatable, which is why I suggested that this is probably not something that you can hold up as a requirement under the principle of effectiveness to start the clock. Okay, so we've had fundamentally three cases that we can turn to clarify what are the limits deriving from EU law for limitation periods. The first was Manfredi, who told us that if the limitation period starts to run from when the infringement occurred, this may violate the principle of effectiveness, especially with short limitation periods and for continuous infringements, because the time barring can occur prior to the end of the infringement. I think what is most interesting about Manfredi is how non-committed the court was with solving the specific issue. They really left a lot of margin for the national court to apply the general idea, the general principles, and to determine if there was a violation of effectiveness. I'm saying this because then in Cogeco, that doesn't seem to be the case. We also had the issue discussed before the EFTA court in this case, which I will not try to read. It was just like Cogeco, it was a case of abuse of dominance where the NCA investigation occurred because there was a complaint by the company, who then, after the decision of the competition authority, filed a follow-on action. And so you're going to find very similar discussions in that EFTA judgment as you find in Cogeco. And at this time, I would like to not discuss so much Cogeco, because I am acting for the claimant, and therefore I don't want to take the, I would obviously be biased in this discussion. But I am very happy that we have had the honor here of counting on the participation of Mr. Martijn van Maanen from BarentsKrans in the Netherlands. Mr. van Maanen has been arguing private enforcement cases since before most people have even heard about the possibility of such a thing. He has a really extensive track record. He's one of the most experienced litigators in the Netherlands. And so I'm very happy to have him participate, especially because he argued a case before the, if I'm not mistaken, before the Amsterdam Court of Appeal recently, where Cogeco was discussed. And that being said, Mr. Van Maanen, you have the floor.
Well, thank you very much for allowing me to share some thoughts with you on what I believe is indeed one of the most interesting subjects in private enforcement today. Just a little bit about the practice that we run in the Netherlands. Our intent has always been not to focus on national cases, but on cases that have a pan-European impact. And so what we have done, not only in air cargo, but certainly also in trucks and in paraffin wax and in sodium chlorate, is to try and serve the interests of parties that suffered damages as a result of the infringement all across Europe. And so their claims were assigned to a special purpose vehicle that acted as the sole claimant in the Dutch proceedings. A model which has now been embraced by the Damages Directive, which offers the same rights to an assignee as to the original injured party. And this model has also been approved by the Dutch courts. Now, one of the interesting things of that model is that you can indeed have parties from all across Europe assign their claims even after the proceedings are already running. Whereas normally, of course, you cannot add plaintiffs to a case, but certainly here you can assign claims after the filing date, and all the SPV needs to do is actually amend and expand its claim so as to introduce those claims into the proceedings. Now, that has been very, very effective. And the cases that we've handled, one of them I'm going to discuss today, they have focused on limitation issues prior to the introduction of the Damages Directive. And certainly, as Miguel just said, in Cogeco, the ECJ already said that the Damages Directive would not apply to the case at hand, and that all of this would have to be decided under the principle of effectiveness. Now, the first case we started, air cargo, we already wrestled with that issue as to when limitation periods would actually kick in, when they would be triggered, when they would expire. One of the reasons in air cargo was that it was a worldwide cartel, and there were fines, there were decisions, there were settlements in other jurisdictions that could weigh in determining whether a victim in the European scene would already have gained knowledge about the infringement and about its potential damages. So for us, it was critical to start that proceeding even before the press release of the Commission. And we only received a non-confidential version of the decision in 2015, when the case was already running for 5 years. So a lot of the problems that were identified by Miguel in his discussion in the past hour sound very familiar to me. And we didn't know what would happen. We certainly didn't know that the ECJ would be as forthcoming as it was in Cogeco in coming to the aid, if you will, of injured parties. Now, the case that I want to discuss with you now is called CDC Chimera, and it is actually a sort of follow-up on Cogeco. I will deal with Cogeco in a moment, but CDC Chimera deals with the sodium chlorate cartel, which is used by the paper industry for bleaching purposes. So in order to have white papers, and certainly the paper industry wants to have white papers, they use sodium chlorate, and the sodium chlorate cartel included parties like Axo and Arkema, but also Aragonesas and Chimera. Now, interestingly, Chimera was the only party that did not appeal the Commission's decision. And so one of the questions that would have to be addressed here was whether there was finality of its decision long before there was finality in respect of the other cartel members. The other cartel members only decided to throw in the towel after the General Court had confirmed the decision of the Commission, which was in 2011. But Chimera didn't appeal, and so there, arguably, the limitation period would already have resumed in 2009 when it decided not to appeal, so that there was res judicata in respect of Chimera. And so that was one of the critical issues that the court of Appeal in the Netherlands had to evaluate. But the Court of Appeal also had to deal with issues not only under Spanish law, where this particular issue played a role, but also under Finnish law, Swedish law. And before we dropped the claims, they also had to look at Slovak and Czech law. And Dutch courts are familiar with foreign law. They don't shy away from deciding issues under foreign law, but still this was quite an exceptional case. And we were very lucky that, 1 year before the Court of Appeal had to decide on limitation issues, after a very unfortunate decision of the District Court, the ECJ rendered its decision in Cogeco. And what the Court of Appeal was then allowed to do is subsequently copy-paste the most important paragraphs of Cogeco and decide that none of the claims that CDC had brought against Camira was actually time-barred, either because the limitation period had not expired or because it had expired, but that would render the enforcement of those claims by a victim practically impossible or excessively difficult. So on all counts, it was a massive victory. And the interesting thing is that the interpretation that the Court of Appeal gave to Cogeco may actually encourage other courts across Europe to do the same. I have provided an English translation of the judgment to Miguel, so I'm happy for you to share it with the group so that they can read what the Amsterdam Court of Appeal decided. Now, turning to Cogeco, I know very little about Portuguese limitation law, and I understand that the limitation law as it was interpreted by the ECJ, the Portuguese limitation rule, may not have been entirely correct. That I don't know. What I do know is that what the ECJ did was quite radical. If you look at the decision, what they said was the central question was whether the Portuguese rule on limitation would actually conflict with the principle of effectiveness. So they targeted the rule itself. They didn't target the application of that particular rule in the circumstances of the case, which is what any court exercising restraint would normally do. All of that restraint was absent here. They decided to go all out. They actually declared that the Portuguese limitation rule was irreconcilable with the principle of effectiveness, even when there are several instances also identified in the judgment itself where an injury might not have taken place, where the principle of effectiveness might not have prevented the application of the rule. But they didn't look for exceptions that would more or less allow the victim to bring his claim in time and that would actually require the victim to do something. Instead, they got rid of the entire rule. And that is quite radical because it was a message to national courts that they could do the same thing. What the ECJ did was actually provide an example of how such a subject should be treated. And for any court to dismiss the limitation rules of its own country, it is already quite a big leap. But to do that in respect of foreign limitation rules is extraordinary. And we knew that the court might actually shy away from that. So what we advised the Court of Appeal was that they need not sort of copy-paste the example of the ECJ. It would be sufficient for our purposes if they would say that the application of a particular limitation rule under foreign law, the application would actually conflict with the principle of effectiveness, and that the limitation rule should therefore be disregarded, but not cast aside entirely. So you see that the ECJ is quite radical in its approach, and one of the reasons is that it's not a weighing exercise between the interests of victims on the one hand and the infringers on the other. You will see no reference at all in the judgment about the need to also keep in mind that limitation rules serve a purpose in terms of legal certainty for the party committing the wrongdoing. There's no wording there whatsoever which attaches any value to that particular issue. And so you know, if you look at the national regimes, certainly the principle of equivalence would suggest that you cannot discriminate against claims that are based on the infringement of European competition law, but you do not necessarily have to treat them better than other claims. And in most national regimes, you will find that limitation rules also serve objectively a valid purpose, that is the purpose of legal certainty. So if you would rely on the principle of equivalence here, the treatment of the claims in Cogeco would have been quite different. Instead, you could fully rely, as Cogeco indicates, on the principle of effectiveness, and it is my argument that private enforcement claims, courage-creating claims, as I call them, are actually treated more favorably in terms of limitation than most other tort claims under Dutch law or any other laws that I've encountered. Now, what are the main paragraphs of the Cogeco decision that you should keep in mind in respect of the evaluation of any limitation rule, whether it be subjective or objective in the European Union? The central paragraph is paragraph 47, in which the ECJ basically decides that any limitation rule which would apply to competition law claims must be adapted to competition law and also adapted to the objectives of claims for compensation in this context. Virtually none of the limitation rules in the European Union meets that requirement. Most limitation rules that are applied to these sort of claims are general limitation rules that have no particular wording which is focused more specifically to competition law claims. Now, of course, they may be after implementation of the damages directive, but certainly if you look at the older situation, what you would simply say is that the normal limitation rules for tort claims, for instance, would also apply to courage-creating claims for compensation as a result of an infringement. So none of them were actually adapted, but it's a requirement that is set out in paragraph 47. And it's critically important for the determination of what the principle of effectiveness actually requires those limitation periods to do, because they should be suitable. Suitable and it means that they should not interfere with European Union law and the guarantees offered by European law. And it should also not render as we know, render the enforcement of courage-creating claims practically impossible or excessively difficult. Now, what the next paragraph, which is critically important, is 52. 52 basically sets out, as Miguel just said, that in respect of follow-on claims, you are entitled to wait until there's a final decision. I can tell you we've been litigating air cargo for more than 10 years now. There's no final decision in sight because there's still an appeal pending at the General Court from the airlines against the decision. And we can expect that they will go all the way to the European Court of Justice. And all that time, there's no finality in the sense of paragraph 52. So arguably, none of the claims in air cargo in the market have expired to date. Because that would be contrary, the ECJ says, to the principle of effectiveness, which is sort of strange because, I mean, I recognize that Miguel says you can't ever be certain unless there is finality. But certainly we do have the non-confidential decision of the European Commission. And there's plenty of juice there on which we can actually substantiate our courage-creating claims. So to sort of suggest that we lack the sufficient knowledge to bring a claim, even though we've been litigating this for 10 years, it's sort of strange. But it's a windfall that the ECJ provides to victims, which is entirely in line.
I'm sorry to interrupt. I just can't resist asking you a question. What if the Commission is wrong? Sure. What if the Commission made it all up?
Yeah, no, I agree. They may be wrong, but in terms of in order for limitation periods to kick in, and even for limitation periods to expire under most national regimes, you do not need to have absolute legal certainty about the basis for liability of the wrongdoer. And so, you can't just say, well, we'll wait and see until we have a final decision. It's simply because it is granted by the damages directive. It is construed by the ECJ as the logical consequence of the principle of effectiveness. But surely, in the Dutch legal context, I'm filing many claims before I know that the defendant is liable. Whether he is liable at the end of the day may depend on many things, but certainly, I can't wait with filing a claim until I have such absolute certainty. But the critical thing is that the ECJ actually, whether you know about the public enforcement proceedings, because there has been a press release, a non-confidential version, etc., or you don't, it doesn't really matter. You are entitled to wait until there is finality, and as you said, even then you will have a period after that before liability issues may really kick in. Now, what I should perhaps add is that, for instance, in trucks, the example that you gave earlier, the interesting thing is that 5 of the 6 parties have decided to settle. I think, personally, because I'm a litigant in trucks also on behalf of the claimants, I think that was done deliberately. They want to be able to invoke limitation rules, saying that there was finality in their case. And so you should rush. And certainly the message that they had for the market is that there was no need to rush. There was no need to make any claims just yet. But in due course, they will invoke the limitation rule. And for instance, in Germany, they will say, look, you were too late to bring your claim because we settled with the Commission. And so we did not appeal. And that decision is final in respect of us. Now, that is what Camira said in the CDC case, and there the Court of Appeal disagreed and said no, because CDC had brought claims on behalf of injured parties that suffered damages as a result of the entire cartel. They were entitled to wait until the decision of the General Court was rendered in respect of the appeals filed by the others. You were the odd one out. And so you couldn't just say that time already started to run in respect of Camira, even though it was not even clear whether there was actually a cartel. Suppose indeed, Miguel, that the General Court had said that there was no sodium chlorate cartel. What would you have done? Would you have expected a court in private enforcement proceedings to ignore that simply because Camira did not file an appeal? Could they be held jointly and severally liable for the entire damages caused by the cartel, which was deemed not to exist by the General Court? And so that was a huge problem. And they said, Camira can't rely on this. But here in trucks, it's the other way around. You have 5 out of the 6 admitting that they formed part of this cartel. You have Scania, who is the odd one out. And I, for sure, wouldn't want to rely on the decision in Scania, which may be many years away, and say that all claims against all members of the truck cartel will not face any risk under limitation rules until we have finality in respect of Scania. I just think that is too risky. Anyway, we do know now that you're allowed to wait until there's a final decision, but that's not the end of the matter, because as you said, Miguel, the ECJ also recognizes in paragraph 46 of the decision, which is the third critical paragraph, that a party who wants to bring a private enforcement claim, in order to do that, must conduct a complex factual and economic analysis. And the ECJ does not say that that is required in order to succeed in the claim. The wording used in several European languages suggests that the ECJ believes you should do that prior to bringing a claim. In other words, you must have the opportunity to determine whether you suffered any damages at all before you are required to take action. You are not supposed to shoot first and ask questions later. You are not supposed to file a case before you even know whether you suffered damages, out of fear that the limitation period will otherwise prevent you from bringing a claim at all. The ECJ actually supports the idea that you do your complex factual and economic analysis before bringing a claim. Now, most of these investigations into overcharge, etc., will last long into the proceedings. So, in practical terms, you're almost you don't file when after your expert has more or less concluded the investigation. But certainly, you need to make an assessment whether the parties that you represent actually suffered damages, whether they have a credible case for damages, and then you are allowed to bring your claim, and you don't need to fear limitation periods anymore. What is if we take all this, the central message seems to be that you don't need to fear limitation periods in the European context as far as public enforcement claims are concerned. But that may be a little too optimistic. I think that the CDC judgment that Miguel will share with you points to what is really one of the more intricate problems. One is that you can be reasonably assured that if a limitation period has already expired before you had the requisite knowledge to bring a claim, that Manfredi will prevent the application of that rule because it would conflict with the principle of effectiveness. The gray area is whether if you have sufficient knowledge to bring a claim, but for instance, the objective limitation period will expire less than 1 year from now, whether you should file or take action within that 1 year, or whether that would be excessively difficult under the Manfredi principle of effectiveness. And there, the Court of Appeal decided in respect of Finnish law that there were only 4 months after, I think, the press release to conduct an investigation into potential damages, and that was really too short under the principle of effectiveness to allow that particular limitation period to be invoked against the victims. In other words, 4 months to have the requisite knowledge, and then only to have 4 months to bring or preserve a claim would not be sufficient and would conflict with that principle. The interesting thing is, Miguel, you said a moment ago that the duration of the limitation period may not be critical. It is really the starting point, whether you should look at the moment that a particular overcharge is implemented in year X, or whether the limitation period should only start to run at the end of the cartel. The interesting thing is that you would believe that the latter option is more favorable to victims. That you would say that the limitation period, the objective limitation period, will only commence at the end of the cartel, and not start each and every time that the infringement is committed and that you have to pay your overcharge. But that may not actually be true. In the Finnish example, if you would simply look at the time that the infringement was committed each and every time, and you would add another 10 years, then clearly under the Manfredi principle of effectiveness, you would have to conclude that all the claims had already become time-barred before you had the requisite knowledge. It was Chimera as the defendant which said, no, the objective limitation period will only start to run at the end of the cartel. So then I had to add another 10 years, and you had the requisite knowledge in year 9. So now all your claims have expired. And so you see that depending on the circumstances of the case, it may be the defendants who argue this and not the claimants. So in that sense, it was a very, very interesting and dynamic debate. But the real takeaway, I think, of the decision of the Amsterdam Court of Appeal and its reading of Cogeco is that none of the claims have become time barred. And if they were, the principle of effectiveness would have prevented it. Now, my question would be whether this is actually beneficial to victims. Arguably, you would say, yes, because your claims do not expire. But one of the problems that I face as a litigator in private enforcement is that usually if I represent a large group of claimants through the assignment model, the companies that I sue will only be prepared to discuss settlement if they're reasonably certain that they will obtain closure by dealing with me, which is not going to be the case if all the other claims in the market are still alive. And so the message from the ECJ and Cogeco and the damages directive is that many of these claims will remain alive for a considerable period of time. In air cargo, we know that all the claims will be alive until 1 year after there's a decision by the ECJ, irrespective of the appeal against the air cargo decision. So it's going to take years. And that means that the defendants in our case will not get closure, even if they settle with us. They actually run the risk that such a settlement will inspire others to bring claims. And so the drawback of providing more protection in terms of limitation to victims is that it's much more difficult to get money for the victims who actually decide to sue. So those are my first comments, and perhaps I may add just one other about zombies. I was intrigued, Miguel, about Cocot's statement that we wouldn't allow any zombie actions. I'm pretty sure she disregarded the effect of Rome II. And Rome II is critically important for cartel behavior after January 2009. Rome II allows you to have the courts that you seize, where you bring the claims, for instance, the Dutch court, to apply its own laws, the lex fori, to all the damages claims that you bring. And so what that means is that if I have a pan-European claim that I can bring in the Netherlands because the Dutch market has also been substantially affected by the cartel, I can ask the Dutch court to apply Dutch law to all the damage claims that I bring. Now, those are damage claims from Spain, where you would ordinarily have just 1 year. Those are damage claims from Germany, which also has a less favorable treatment of limitation. And so arguably, if you would go around the European Union, there would be lots of claims that would otherwise have already expired under their own applicable laws. But once you introduce them into a forum in the EU, which as lex fori has a more favorable limitation rule, then all of these claims will revive. So that, I think, whether it's zombie or not, I call it the Lazarus effect, that all those claims that were already dead and buried can be treated as alive once you have the court apply the lex fori. So in that sense, I don't think that Cocotte can safely rely on her statement that zombie actions will never be allowed. Thank you.
Oh, thank you so much, Martijn. Thank you for this wealth of information and so much food for thought. Not that it is my place to come in AG Cocotte's defense, but she was addressing a case where that was never going to be relevant because the facts of the case would not make it relevant. Yeah, fascinating presentation, and thank you so much for all your contributions. In the meantime, we've had a very interesting question from Ignacio. He said, well, what if, we're saying that the decision only when the decision is final can the deadline start to run, but what if the appeal only concerned the fine? Yeah, that has been discussed several times amongst academics, and I think the idea there is that the finality has to concern the infringement and not the fine. The fine itself is not relevant for the finality for the purposes of actions for damages. So I think that their decision would be final for the purposes of the directive or for the principle of effectiveness. And I now have to go relatively quickly, but we don't have much left, especially because Martijn has already addressed the issue of the absolute or objective limitation period somewhat in his presentation. But I would like just to call your attention to the fact that the absolute limitation period is going to be a problem in many cases. Let's come back to our hypothetical trucks cartel case that I gave you at the beginning of this lecture. Some of the trucks bought in 1997, if you were to apply the Portuguese absolute limitation period, which is about average in the EU, they would be time barred by 2017, those purchases. At least this is one way to interpret how the absolute limitation period in Portugal would apply. What are its consequences? Everything's debatable. But if that is true, are you in a kind of Manfredi situation where even before you have been able to exercise your right to damages and you were aware of the infringement, because you didn't even have the non-confidential version of the decision, for example, you have become prevented from doing so? Or is it different because we're not talking about the relative limitation period, we're talking about the absolute limitation period? And here, we've gone over this already, and I think from Martijn's intervention, the answer to this should be clear. It's the Dutch, the Amsterdam Appeal Court has already expressed its opinion on this, and so to structure our thought, I would say that we have lots of case law from the court that says that, as a rule, absolute limitation periods are fine. It's part of ensuring legal certainty, and you have to have them. There is no rule on this issue specifically in the directive. We can try to interpret Article 11.4 as having some implications for it, but it's not set out there clearly. What is also clear is that absolute limitation periods, as Martijn made it very clear with his examples, they can destroy the effectiveness of the right to damages, especially if you're talking about continuous infringements that lasted for many, many years. By the time the absolute, depending on when you start counting the absolute limitation period, by the time when it's over, you might not even know about the infringement, or you might not have had enough time to react. Thank you so much, Martijn. I'll see you. Thank you so much. And we then have the issue of the principle of effectiveness. Does it apply to absolute limitation periods? I think it has to. I think it has to. Otherwise, you clearly will be prevented from. Again, it has to be on a case-by-case basis, because it depends on when you start to count it. It depends on the circumstances of each situation. But as it has been interpreted in Portugal, for example, the end result in our hypothetical case would be that some of these trucks would be time barred even before the person was in a position to exercise its rights, right? That is true for the big group of defendants in the first decision, but that would especially be true for the second decision, for Scania. I think that we don't have to be this is not novel ground. We can turn to the case law of the European Court of Human Rights in the case of Howell Moore, where there the court looked at an absolute limitation period in Switzerland. This was an asbestos case, so it's not an antitrust case, but I think you can extrapolate the logic. The ECHR said that there was an absolute limitation period for torts of 10 years, and this infringed Article 6.1 ECHR in the specific case. So based on a case assessment, based on an assessment not of a general problem with the rule, but of how it played out in those circumstances, because the victims' rights were time barred before they were even aware that there was a problem and that they had a right to damage. So very similar to the Manfredi approach. And I think it's clear from this case of the ECHR that exceptional circumstances have to be present, because usually there's nothing wrong with an absolute limitation period. So, but these situations of cartels like the one we've been discussing in our hypothetical example, that's the example of an exceptional circumstance, right? Secret cartels that last for a long time, and that are only discovered basically 20, 15 years down the road. The judgment also makes clear that you have to have a kind of proportionality assessment of the conflicting interests and principles. And that's also compatible with the approach that the European Court has had to these cases. So, of course, there are several things you're going to have to take into account. I don't want to go into these one by one because we've already kind of discussed them. But I think I would say that the rule of thumb for absolute limitation periods is if you have a cartel that was willfully kept secret or a practice that was willfully kept secret, when you're assessing proportionality, you have to take that into account. That you don't need to protect the interest of legal certainty for the cartel members. Otherwise, you're rewarding them. It doesn't merit protection. They were successful in keeping an infringement of the law secret. Good for them, but why should people not be compensated just because of that? And furthermore, as part of this rule of thumb, I would say that a reasonable deadline, and there the directive has argued apparently that a reasonable deadline is 1 year. A reasonable deadline should be granted to the victims following the moment where they become aware of the infringement, because it is going to take some time for them to be able to prepare the case, to file it. I mean, it takes months and months to prepare one of these actions. Anybody who's done it knows so. And so to require a much faster reaction would be, in effect, to make the exercise of that right excessively difficult. Because you would have to file very quickly, and this would most likely be condemning your action to failure by not preparing it properly. As Martijn already addressed, I think we can take implications from COGECO for the absolute limitation period, and this was addressed in relation to Finnish law by the Amsterdam Appeal Court. I have one question here. Someone says, if you acknowledge the infringement settlement procedure, when does the decision become final? The decision only becomes final when they don't appeal it, because they promise not, when they settle it, they promise not to appeal it, but that doesn't mean that they can't change their mind. They can change their mind, and they might still appeal, in which case the obvious consequence is that they will lose the reduction of the fine that they were granted. But they legally still have a right to appeal, so the decision is not final until the deadline for the appeal has expired. And I would now like to turn to the decisions of national courts so far, and I'm basing this mostly on the research by Professor Francisco Marcos that I already quoted yesterday. There have been obvious, widely diverging interpretations of the limitation period in the trucks cartel case. And of course, this will be true in other cases, even within the same member state. So for example, in Spain, out of a universe of 96 judgments that have already been issued, 96 cases actually, because sometimes more than one judgment in the same case. But 96 cases, 16 of them found that the rights were time barred. Of course, you can't jump to conclusions because this has a lot to, you have to look at the facts of each case. But ultimately, there is evidence here of cases that were deemed time barred because of different interpretations of the law. So for example, 5 of these 16 were deemed time barred because the interruption or the suspension of the limitation period was deemed to be applicable to the parent, but not to the subsidiary who was being sued. In others, some cases said that the deadline would start to run from the European Commission press release, whereas the vast majority have said it started to run from the publication of the non-confidential version of the decision. In that respect, it's interesting especially if you're from Spain, to check out the Supreme Court judgment of 2013, which even back then already looked at the not directive but the proposed directive and said, you know, well, they're proposing this. This apparently is what is required by effectiveness, and they interpreted national law along those lines because they thought it made sense, even under national law, to arrive at the same solution as to when the deadline would begin to run. But just like you have judgments that are overly restrictive, you also have judgments that might be, might go to the other extreme. So some cases, it's very rare, but some judges have said that it didn't even start to run at the publication of the non-confidential version, because you would have to show specific subjective knowledge by the injured party, and this hadn't been proven. that might make it, arguably a prova diabolica. How will the claimant be able to prove subjective knowledge, actual subjective knowledge by the injured party in a specific case? So you get solutions on both extremes. And this is it. We still have 5 minutes for questions. I mean, we've had a lot of thought-provoking interventions. I'm so thankful to Martijn for his wealth of knowledge that he shared with us. And if somebody has questions to ask, either in writing or by turning on your microphone, please do so now. So Sander asks, on the rule of thumb, a limitation period might protect legal entities who are regarded as infringers, but did not themselves take part in the cartel. Or otherwise, like in the truck cartel, it can protect subsidiaries who might be sued in cases where parent companies were in a cartel. Not sure, I'm having a little trouble maybe interpreting the question. So how can you regard a legal entity as a, maybe you can turn, if you can turn on your microphone, Sandra, and discuss this with me, I'd be curious to understand it better. How can you? Yeah.
I'm here. Well, maybe you can go back to the slide where this rule of thumb, maybe I interpreted it wrong, but there you said, well, if the cartel was willfully kept secret, we shouldn't grant any legal certainty, or this legal certainty idea shouldn't be awarded because, well, you willfully violated the rule, the cartel rules. But it might be the case for those subsidiaries or parent companies, like in the elevators cartel.
I think I understand. I think I understand the root of your question. If I am understanding your question correctly, you are thinking about this as a traditional civil lawyer. And so you're thinking of liability as attaching to legal persons. And so you are discussing whether a legal person which did not take part in the cartel, did not keep it secret, whether this argument would also apply. The problem with that is that liability under competition law is not assigned to the legal person, it is assigned to the economic unit. And so the economic unit kept the cartel secret, the economic unit is responsible for it, and so it doesn't, but this is not, and ultimately, this is a really interesting discussion, but it goes a little beyond this. Ultimately, if the subsidiary kept it secret and you're holding the parent company liable, the parent company did control the subsidiary, could have controlled the subsidiary. If it didn't know, it should have known. It should have done a better job in compliance and internal control, and it is part of the economic unit, it's held liable. If it's the other way around and you're holding the subsidiary liable, you might say, well, you know, the subsidiary is going to have to pay out of its accounts, and that's not fair because it didn't know, and blah blah blah. That's all very well and good, but it's inside the group, it's inside the economic unit, and it's up to its parent company to decide to to exercise the right of return or not within that group, and to compensate it for the damages that it's paid out. So ultimately, it's not going to be unfair for the group, for that economic unit. But I understand, it's such a complicated discussion. Thank you so much,
Thanks,
Sander. And Petra asks, what sense does it make to suspend the limitation period during the proceedings if the limitation period does not start running before the decision was even adopted? Yeah, I understand your predicament. The issue is that it might. The reason why you need that rule for the suspension during public enforcement investigations is that sometimes you might have a situation where a court would say that you already had enough knowledge before the public enforcement investigation. And Cogeco and Nijlink, I'm sorry, I don't want to, I'm probably saying that wrong. They're examples of that. They're examples where a company complains to a competition authority. And so some courts, including Portuguese courts, would say, well, if you complained about the behavior, you already knew about the behavior. And so rather than going into a complex debate about whether indeed you knew about the behavior or not, The suspension rules allows you to sidetrack that and say, well, it doesn't matter. It's suspended during the public enforcement investigation. And of course, in other cases, you might really have complete knowledge and you know everything and you could have gone to court and you didn't, and you waited until there was a decision. And then there is a policy discussion, which is does it make sense for the suspension, for there to be an automatic suspension? Well, there are two levels of that discussion. One, after the directive rules are applicable, the discussion disappears and it's just a political discussion. Should the legislator have done that? But it did. And the other levels of the discussion is under the principle of effectiveness, prior to the directive, can you also suspend it? I say, and I think Martijn agrees with me, that COGECO says, yes, there should be an automatic suspension during the public enforcement investigation. And that is intimately connected, I think, to the degree of complexity of antitrust infringements that would make it ultimately too complicated to go on a case-by-case basis discussing these requisites, but also to the idea that private enforcement and public enforcement are the right and the left hand of competition policy, and that we should view them together, and we shouldn't, if there is a public enforcement investigation, we should allow people to wait until that issue has been settled. So, but really, the most important thing is the complexity of these infringements. And with that, I have to end the class, even though there is already another question here, but I have to end the class because we're past our time. Thank you guys so much, and I can address the question that was now asked in the next class if you ask it then. Thank you, and I'll see you back here tomorrow.
Thank you very much.
Thank you.